thank you for coming out on this just nasty day here in the fall. I hope there's going to be some leaves left on the trees for people who want to come touring around over the next couple weeks. So thank you for braving the weather for this. My name's Dan Forrest. I'm Lieutenant Governor in North Carolina, and we wanted to put together this educational opportunity for you to have an opportunity to talk to Dr. Michael Farris and ask some questions, and he's going to do a presentation for you about the project of the Convention of the States, and we'll kind of make it dialogue driven if we can. I'm going to lay out a couple ground rules that we just make sure that everything remains civil. I know there are people probably that fall on all sides of the argument related to what's better, the Convention of the States or nullification or all these types of things. And Dr. Farris will talk about those things, but when we get to the Q&A time, let's just be respectful of one another when we have those conversations. That's really the ground rules here. Feel free to make this casual. If you need to get up and use the restroom, feel free to go do that as well. Just down this hall, around the corner, and we'll just make this a casual evening. So hopefully you'll leave tonight loaded with some information you didn't have before, as we start to move forward with the process of figuring out how do we save the republic that our founding fathers created. I think we have a great challenge in America today. The America that was established through the Declaration of Independence and the Constitution of the United States is not very similar to the one that we see today. And you look at our, I was just looking at the national debt clock on the way up here, just curious as to where we stood now, almost $18 trillion in debt. About every 10 minutes we had $5 million to our national debt. If you're a tax-paying citizen, you owe nearly $1 million for unfunded liabilities in America. $1 million if you pay taxes in America. So we have about $115 trillion of unfunded liabilities in our country. And I know you would agree that's unsustainable in America. We have to balance our checkbooks at home. We have to balance our checkbook here in the state of North Carolina. We have a balanced budget amendment here in North Carolina. That's a good thing. I believe we need a balanced budget amendment at the federal level to keep the federal government in check so that they don't mortgage off the futures of our children and our grandchildren. And so there's a lot of issues related to fiscal responsibility from the national government. There's a lot of issues related to all kinds of things that we could talk about tonight. I'm going to let Dr. Farris take the agenda so I don't get into his weeds too much here tonight. But we also have this issue that we don't talk a lot about in our country anymore. We have some understanding of what I call the horizontal separation of powers, the executive, legislative, and judicial bodies. And we learned that in school. We kind of studied that and talk about those separation of powers. We don't spend a lot of time talking about what I call the vertical separation of powers, the separation of powers from the national government to the state governments. And you all know that through the 10th Amendment of our Constitution that everything that is not expressly spelled out in the Constitution of the United States is afforded to the states themselves to make those decisions. And we've gone a long way from that in our country, and we need to get that back. There are powers that our states deserve to have, and rightfully so, and we need to make sure that we have a way to get those powers back. And so Dr. Michael Farris is an expert on this topic. He is a teacher of constitutional law. He's been doing that for a number of years. He's the chancellor of Patrick Henry College. Dr. Farris, I don't know if you know this or not, but if you walk outside your main building, my wife and I have a brick out there with our name on it. We've been supporting Patrick Henry College as a homeschool family long before it even existed, hoping that my kids would one day go and be taught by Michael Farris. They didn't, but it's a great school. It's a phenomenal school. I have a number of friends there, and he's training up the next generation in just a great way. These are phenomenal students. And he's also the founder of Homeschool Legal Defense Association as well, so been supporting his organization there as homeschoolers for a number of years. But his greatest battles have happened in the courts of the United States. He has gone before the Supreme Court of the United States. He's gone before numerous appellate courts in the United States to argue about the foundations of our society and our culture. And so there's no better scholar on the Constitution. There's no one better to talk about this issue than Dr. Michael Farris. So please join me in welcoming Dr. Michael Farris.
Dan, thank you so much. It is great to be with all of you tonight. But Dan, thank you for the honor of hosting this meeting and your support and help on this issue. One of the reasons that I'm such a big fan of state government as opposed to what's going on in Washington, D.C. is because of leaders like you. You're a tremendous leader for North Carolina, and we just appreciate your leadership in this state. I want to start with an observation that might take you a little bit by surprise. People think that we're not following the Constitution of the United States. But you know, I get that. I get why people think that. I get why people are frustrated by that. But it's not the most precise way to say what the problem is. Because what's happened is there are effectively two constitutions in the United States. There's the Constitution as written by the founders, and there's the Constitution as interpreted by the Supreme Court of the United States. And those things are rarely the same thing. Our federal government actually does follow the Constitution pretty much of the time. Most of the time, it does follow the Constitution, but the wrong one. It's following the Constitution as interpreted by the Supreme Court, rather than the Constitution as interpreted by the Founding Fathers themselves, as intended by the Founding Fathers themselves. And the fundamental task that we have in this country is to return our nation to the Constitution as written, as opposed to the Constitution as interpreted by the Supreme Court. Now, when you start thinking about how do you fix the Supreme Court, which is really a big part of the problem we're going to talk about tonight, not very many people have ever been involved in successfully doing that, but I have done it at least once. Now, some of you, well, in fact, just about all of you are familiar with the Hobby Lobby case that was decided by the Supreme Court this past June. In that case, the Supreme Court ruled that Hobby Lobby's religious freedom could not be thwarted by a neutral general law that applied to all businesses, requiring all businesses to pay for abortion coverages. Now, there's multiple violations of the Constitution embedded in that, but the one we're going to talk about right now, we'll come back to the other ones later actually, is the fact that the Supreme Court did find in favor of Hobby Lobby based on the Constitution. The First Amendment free exercise clause should have been the basis for the Supreme Court's decision, but it wasn't. And the reason was in 1990, in a case called Employment Division versus Smith, the Supreme Court made an outlandish ruling about religious freedom that required the adoption of a federal civil rights statute called the Religious Freedom Restoration Act. And it was on the basis of the Religious Freedom Restoration Act that Hobby Lobby won its case. Now, I'm the guy who named the Religious Freedom Restoration Act. In fact, I'm the person who was the chairman of the group of lawyers who wrote it. Now, it was a really strange group of people who wrote that law, because this was in 1994 when Bill Clinton was president and both houses of Congress were controlled by the Democrats. And the meetings I would go to of the Coalition for the Religious Freedom Restoration Act looked like the original bar scene or the cantina scene in Star Wars. Remember that you would walk in with all the, I was there with People for the American Way and the ACLU and all these other groups. Now, the reason that all the ACLU and the People for the American Way were there is because the Jewish groups were taking a strong lead for religious freedom for everybody. And they got it right. And the Jewish groups and some conservative groups, and I was pretty much the lead evangelical Christian conservative that was in the group writing this law. The Jewish group said to the ACLU and the others, look, we've stood with you a long time. It's time you stand with us on the free exercise of religion. They called in all their chits. And they forced the ACLU to stand for the right thing on this particular one. And the ACLU, like the Supreme Court, like a broken clock, gets something right, once a day for 1 second. And so anyhow, that's how that law came to be. It was a Religious Freedom Restoration Act that the Supreme Court ruled. In fact, the judges, the very judges, or at least some of the judges, that wrote the wrong opinion back in 1990, joined with the majority. We reversed the Supreme Court. So it is possible to reverse the Supreme Court if you know what you're doing and you do it in the correct fashion. And you have the right principles and right convictions, and you want to go in the right direction. That's the Hobby Lobby story. But we need to do Hobby Lobby times 100. Times, well, maybe even a bigger number than 100. But a big multiplier times the Hobby Lobby. So let's just start talking about what some of the issues are. Dan laid them out very well. The problem of spending comes from the Supreme Court misinterpreting the General Welfare Clause. James Madison's interpretation of the General Welfare Clause is this: it is not a grant of power, it's a limitation on spending power. When you use your otherwise enumerated powers to tax and spend in the Constitution for the military, for national defense, for other, like the patent office, there are 19 specific things in Article 1, Section 8 that are of the nature of the patent office. When you are spending money for those things that are enumerated powers of Congress, you have to do it in a way that's for the general welfare, not somebody's private benefit, so somebody's getting rich off of it, and not so some local project. It's got to be for the national benefit and not for somebody's private benefit. That's Madison's view of the General Welfare Clause. Not a grant of power, but a limitation of power. Hamilton's view is similar, but it's a little different. It's a little more liberal, if you will. Hamilton's view was joined by George Washington and some other, really good people. Madison's view was the majority, but Hamilton's view had some respectable other people with him. James Monroe, actually, eventually, John C. Calhoun supported this position, which, really got my attention when I learned that. And Hamilton's position was this. He agreed with everything Madison said about it's got to be for the national interest and not for somebody's private benefit. But he said it was a grant of power and that Congress could spend under the General Welfare Clause, but provided this limitation. If the states can spend money on the topic, the federal government can't.
Say that again, please.
If the states can spend money on the topic, the federal government can't. Well, that's a really good limitation. So it's really simple to figure out Hamilton's view. Can the state spend money on education? Oh yeah. So can the federal government? No, not under the General Welfare Clause, and there's no other clause that grants them the power. Can the states spend money on welfare programs? If they want to, yes, they can. Can the federal government? No, not under the General Welfare Clause. That's reserved power to the state. All the programs that are the entitlement programs that are bankrupting this country come through a different view, not Hamilton's view, not Madison's view. In fact, the only practical differences that I know throughout all of American history between Madison and Hamilton is the Louisiana Purchase and other purchases like it, the Gadsden Purchase, the Alaska Purchase. Purchases of land from other countries. Hamilton would say that was okay. Madison would say you really need to amend the Constitution to give the federal government that power. And I'm okay with either of those views, frankly. And the only other example is the space program. Space program, it's for the national interest. States can't do it. So it passes the Hamilton view, but it wouldn't pass the Madison view. And again, if we were writing the rule from scratch, I really wouldn't mind the Hamilton view. It'd be okay with me. As long as you have the ironclad rule, if the states can spend money on it, the federal government can't. Really simple rule. In fact, that's really the overview of the government our founders thought they were creating. They thought they were creating a government where every level of government had exclusive jurisdiction. One level and only one level of government dealt with each issue. One level deals with education. A different level deals with the military. A different level deals with roads. A different level deals with foreign policy and so on. But one level and only one level of government deals with each issue. It's much more efficient. It's much better for everybody except for the bureaucrats. That's the way it should be. So messing up the General Welfare Clause is a multi-trillion-dollar error, but it's just a mess up of one sentence. You add one sentence to the General Welfare Clause that says, the General Welfare Clause shall mean, if the states can spend money on it, the federal government is jurisdictionally precluded from spending money on the same topic. It's a really simple way to clarify the original meaning of the General Welfare Clause. Same thing is true about the Commerce Clause. The Commerce Clause, in fact, before I tell you about the Commerce Clause, we talked about Shakespeare. A little bit of a weird thing. You weren't expecting Shakespeare right now, were you? But Shakespeare really helps you understand the importance of understanding the original meaning of words. Probably the most famous Shakespeare scene of all time is Romeo and Juliet's balcony. In fact, I see my publisher in my book, Constitutional Literacy, in the audience. We just spotted him a second ago. And it was from the editor of this book that I learned this. And in that scene, Juliet says, "Wherefore art thou, Romeo?" And you think, why doesn't he speak up? Nobody would have died if Romeo, he's hiding in the bushes. Nobody would have died if Romeo would have stood up right then and said, right over here. But it would have been a lousy play, but it would have been a lot better off for Romeo and Juliet. They would have come out a lot better. Well, the reason Romeo didn't speak up is because in Shakespeare's time, wherefore did not mean where are you, dude? It meant, why are you Romeo? Out of all the men that I could have fallen in love with in my city, why did I fall in love with the enemy of my father? She was asking herself, why did I get myself into this mess where I'm in love with somebody I'm not supposed to be in love with? Now, you can understand why a guy would sit there hiding in the bushes and not speak up at that moment. Understanding the original meaning of wherefore changes entirely your understanding the meaning of the scene. It really does matter, the original meaning of words. The same thing is true about commerce. Just like general welfare clause, commerce meant shipping. Now, a few of you here, not many, but a few of you here are as old as me. And you'll remember the song, Trains and Boats and Planes. That's commerce. It's shipping. Manufacturing's not commerce. Mining's not commerce. Agriculture's not commerce. There is absolutely nothing that goes on inside a General Motors plant that's interstate commerce. Not a blessed thing. Now, when the cars come off the assembly line and they get loaded on the transport truck, the moment that car is loaded on the transport truck, commerce starts, because commerce is shipping. Now, if that truck crosses a state line, it's interstate commerce. If it doesn't, then it's intrastate commerce. But the difference between intrastate and intrastate is just how far is the truck going. It's still just shipping. Now, how do I know? The Commerce Clause is an exclusive grant of power. The first 100 years of Supreme Court cases on the Commerce Clause was about stopping the states from regulating interstate commerce, because the states cannot regulate interstate commerce. Who regulates banking? The states do. The Uniform Commercial Code, which is the core law of all banking law. The reason your ATM card works anywhere in the country, you go stick it in a machine, you get money out as long as somebody hadn't made a mistake. You'll get money out. The machines are going to work. You might have made a mistake, or something else might. But 99 times out of 100, you're going to get money out of the card, because the banking laws work just fine across state lines, because the states got together and said, you know what, it'd be good for our banking system to work flawlessly across the country. And so we don't need Congress. We're just going to propose the Uniform Commercial Code. And every one of the 50 states passed the Uniform Commercial Code. And it's state law that makes banking and checking and all that work just fine across all state lines. Thank you very much. So, if states can regulate banking, what you know is this: it's not interstate commerce. And if banking's not interstate commerce, you know good and well that the creek that flows behind Patrick Henry College is not interstate commerce. But the federal government purports to control the creek behind Patrick Henry College on the grounds that it affects interstate commerce. Now that creek, if there was a rainstorm like this outside, there'd be water in the creek. But 4 days from now, there wouldn't be any water in the creek. And yet, it's because it supposedly affects interstate commerce. By the way, how did it get to be, how did I know that it had to be because of another problem? The Environmental Protection Agency, not Congress, decided that that creek was big enough and wet enough. And they had to do that in a regulation. And I'm not making this up. The regulation is called the glancing goose test. Now, here's how the glancing goose test worked. It was designed to answer. Congress passed the Clean Water Act. And the Clean Water Act had to decide how much, it had the federal wetlands provisions in it. How wet did the land have to be, and how much land had to be wet in order to satisfy the Clean Water Act and be federally protected wetlands? The answer is they decided an acre. Not Congress, but unelected bureaucrats in the Environmental Protection Agency. And how wet did it have to be? They said in the wettest day of 100 years, if a goose flies over your land and sees its reflection in the water, that's wet enough to be a federally protected wetland. Now, no politician ever would vote for such a thing, because here would be the political ads. Congressman Jones doesn't have the sense that God gave a goose. And so there's political responsibility when you vote for such stuff. And Congress, in Obamacare, for example, 2,000 times they said the secretary shall make rules that. The abortion regulation that was the Hobby Lobby case wasn't in Obamacare. It was one of the 2,000 rules that the secretary made. In fact, there are 200 books of rules made by the agencies. Not 200 laws, 200 volumes of laws. I don't know how many thousands of laws are in it's called the Code of Federal Regulation. Every single one of the laws in the 200 books of laws, probably, I'll just take a wild guess, 10,000 regulations. But it's thousands. I guarantee you it's thousands of regulations. Is unconstitutional because it violates the most important rule in the Constitution. Now, you might be thinking, why does it violate the most important rule? The most important rule of any government is this: who has the power to make the rules? That's the most important rule in the Student Council at Patrick Henry College. That's the most important rule of the Women's Ministry Committee at my church. That's the most important rule of the NFL. That's the most important rule in Congress. And that's the most important rule in the UN. Who has the power to make the rules? And that's why Article 1, Section 1 of the Constitution says what it says. All legislative authority is vested in the Congress of the United States. They didn't want the president to make the rules through executive order. They didn't want agencies to make the rules through regulations. They didn't want the Supreme Court to make the rule through so-called judicial interpretations. And for heaven's sakes, they certainly didn't want the United Nations making any rules for the United States of America. So if the agencies have good ideas, when I was the chairman of the Regulatory Reform Committee in Virginia. Unlike Dan, I ran for lieutenant. We both ran for lieutenant governor. One of us is lieutenant governor, and the other one got the silver medal. But after my running mate won, and he appointed me the head of the Regulatory Reform Committee, because when I was running, I kept talking about regulations being a problem. And our recommendation in Virginia was this: all state-based regulations are banned until the agencies presented to the legislature, and the legislature votes them up or down, one way or the other, because there's political responsibility. I testified on this topic last week in Arkansas. Maybe it's 2 weeks ago now. 2 weeks ago in Arkansas. And one of the members of the legislature there was talking about Congress, and Congress giving away legislative authority to the agencies. He said, well, Congress consents to it. Why are we complaining about Congress giving away its rights? I said, Congress isn't giving away its right. It's giving away our rights. Our rights, we have the right to throw the rascals out if we don't like the people who make the law. And when the EPA and the other agencies, where they're making the law, we lose our right to throw the rascals out. We complain to Congress about it. Your congressman says, I'll write them a stern letter. Well, stern letters don't do you a bit of good, I'll tell you that. You know, what you need is the ability to vote the rascals out. And as long as the agencies are making the law, we're violating the most fundamental rule of America, that the people's representatives. Now, why did they not want the president to make the law? He's elected too. You know, you can't say it's just the people's elected representatives. They don't trust one person. It was a Christian worldview of the nature of man. The heart is desperately wicked, who can know it? Power corrupts absolutely. That's why they wanted power diffuse as much as is possible. That's why we had checks and balances. And Dan's exactly right when he says there's vertical checks and balances, vertical separations of power, and horizontal separations of power. He said it exactly right. And so I can cut about 5 minutes out of my talk because he already taught you that. He reminded you of that. And so it's because they didn't want to trust anybody with too much power. So they said, you make the rules, but only on these subjects. And in fact, we're going to give you a House and a Senate to make sure that nobody has too much power. And we don't want the president to make law, because even though he's elected by the people, he's just one guy. And one person should never have the power to make law. Folks, we are being buried in regulations that are crushing our economy. We are crushing our economy with things that simply are not constitutional, and they're not right. Now, some people might think, well, they're the experts on stuff. My wife has a very serious case of Lyme disease. And if it wasn't for her having that, I mean, God works all things together for good. And I learned recently, it doesn't mean He works together for good for me. It may be good for other people. But because my wife has a very serious case of Lyme disease, and I started looking into it, and I figured out that Lyme disease is being harmed by government policy. And these doctors and patients that were dealing with this weren't really equipped to deal with the government policy. And I knew how to deal with that. I got the governor of Virginia to appoint me the chairman of the governor's task force on Lyme disease. We had 4 medical doctors on the commission. 3 of them work for the State Department of Health. The state epidemiologist, the Secretary of Health and Human Services, and the doctors in charge of medical licensing. And then we had a Lyme expert, we had a PhD pharmacologist, and a veterinarian, and a PhD psychologist, because Lyme affects mental issues a lot. And so it was a half government officials and half citizens. We issued a unanimous report condemning the CDC's approach on this, because the CDC is the problem. The more I dug into the so-called experts, the experts were deliberately misleading the American public. It was about politics, not about science with the CDC. And when they tell you that the regulatory state is about bringing expertise to the subject matter, ladies and gentlemen, I'm here to tell you, I don't have the expertise to talk about lots of areas of regulation. But I can fake my way as an epidemiologist after 19 months of hearings on Lyme disease. I know a whole lot about that. And I'm here to tell you, the experts are playing politics. They're not doing science. They use science when it's convenient, but it's basically politics. And if we're going to be playing politics, the people who elect the leaders need to be playing with the power to get the rascals out if they're doing the wrong thing, even in the areas of so-called expertise. Well, we have a debt that's going to crush us. They're spying on our own citizens. The federal government, I'm convinced, I don't care who we send to Washington, D.C. I've seriously thought about running for office from Washington, D.C. If you sent Dan and me and a bunch more like us to Washington, D.C., we'd be up there, we'd try to do the right thing. I'm here to tell you, it hasn't happened in the last 40 years. I'm convinced that Washington, D.C. is incurable from inside of Washington, D.C. We have to do what the Founding Fathers said we should do. Here's what they thought. At the Constitutional Convention, we got toward the end of it, and the proposal on the table was this. If we're going to need amendments, we develop problems over time, and they knew they were going to have problems over time, they just didn't know what they were. In fact, the fact that we needed amendments was proven right away because we added the Bill of Rights. So we had amendments right away. So they knew we needed amendments. The question is, how are you going to get it? And the proposal was, Congress proposes them, the states ratifies. Sounds nice and balanced, until George Mason stood up and said, what if Congress abuses its power? How are you going to get amendments then? Because if they refuse to propose them, it will never happen. And he said, by the way, they will abuse their power. And so he was right on all fronts. He was right on predicting that they would abuse their power, and he is right on saying that they would never, ever propose amendments that would limit their power. So, in response to Mason's argument, they gave the states the power to amend the Constitution unilaterally. Now, you all know that the Supreme Court thinks it is the supreme law of the land. The Constitution says that it's the supreme law of the land, but the Supreme Court says the Supreme Court's interpretations of the Constitution are the supreme law of the land. It's a bit of a perversion. In fact, it's quite a bit of a perversion. But that's their view. And I was thinking about the other day, that may be the supreme law, but the supreme power of the land is the state legislatures. Because only the state legislatures have the power to change the supreme law of the land unilaterally. Nobody else has that power. The Supreme Court can't do it unilaterally. Congress can't do it unilaterally. Only the state legislatures, through Article 5, have the unilateral ability. They have the supreme power. And when the Constitution is being abused in a way that is threatening the liberty of this country, And the threat is no idle threat. We are going to crash. In 2020, 89% of all federal revenue, 89% of all federal revenue will go to just four things. Interest on the national debt, Medicare, Medicaid, Social Security. 11% will be left for national defense and everything else the federal government thinks is supposed to be done. And by the way, I didn't get that number from some conservative organization. That's from the Center for Public Integrity, a left-wing group. How do I know? Arianna Huffington's on their board. So a conservative source says it's 94%. But there's not a lot of difference. And so I'll go with the lower number. The Arianna Huffington's gives us. That's not sustainable, ladies and gentlemen. That's not sustainable. The chances of the federal government crashing our liberty is 100%. The only issue is how long will it be? And our children are going to be living in slavery, denying our children the most fundamental right of all Americans, the right to a Republican government. What is a Republican government? We elect the leaders who make the law as exemplified by the principle no taxation without representation. It's not just taxation, it's all laws, but no taxation without representation is the most famous example of what it means to have a Republican form of government. Do kids get a vote on the taxes that they're going to be paying? No, because once the spending is already done, the tax imposition is there. It is mandatory. Unless you just totally repudiate the country and write off the debt, basically go into bankruptcy, they don't have any choice. They are not being given representation. Jefferson said that multi-generational taxation policy is fundamentally immoral. And it is. It's fundamentally immoral. And that's what we're doing to our kids. So we have a choice. Are we going to do something about it? Or are we going to sit idly by? What we're going to do about it is this. 34 states need to propose a convention of the states for this purpose. To impose fiscal restraints on the federal government, limit power and jurisdiction of the federal government, and put term limits on federal officials, which, by the way, would include both judges and Congress. Now, I'm in favor of term limits on Congress. I'm a whole lot more in favor of term limits for federal judges. Because Congress, theoretically, you can vote them out. Judges, there isn't anything you can do to get them out. By the way, as long as they're at it, I would add to the impeachment of a judge, in addition to high crimes and misdemeanors, the deliberate refusal to follow the original meaning of the Constitution as another basis for impeaching a judge, and I would give that power of impeachment to the states, not to the federal government. And so, as long as we're getting it right, let's just get it right. But those are the things that can be possible. Georgia, Florida, Alaska, this calendar year called for a convention for that purposes. So we're at 3 out of 34. Alabama and Arizona passed it through their House. We ran out of time, legislative time, and we're going to go back this coming year and get through both houses in both of those states. In fact, we're aiming at 20 states in legislative year 2015. North Carolina is front and center in our plans. Pass this through in 2015. Now, I think everybody here in the room is ready to do this, except for one question. Is it safe? And other than that question, I don't think there's any reason anybody here would want to do that. So let me answer the question, is it safe? The answer is absolutely it's safe. Because you have to deal with these kind of questions based on the process of the Constitution and political reality. I'm going to give you one example of political reality. What are the chances of President Obama appointing me to the next vacancy on the Supreme Court? 0, right? If there was something less than 0, it would be less than 0. What are the chances, and if, let's say Bobby Jindal gets elected president, so I'm friends with Bobby Jindal, let's say Bobby appointed me to the Supreme Court. What are the chances of me getting confirmed if the Democrats have more than 40 votes in the U.S. Senate? 0. 0. I'm not even sure I could get all the Republican votes, because I'm more conservative than a lot of those people who need spinal transplants. But the chances of me getting confirmed are 0. We know how to deal with political reality in a number of contexts, because we can do math, okay? And if we can do math, we can figure out that the danger of, it is of course possible. I am fully qualified to be on the Supreme Court of the United States. It is theoretically possible that can happen, but if you just have any dose of political reality whatsoever, the chances are 0. And so if the other side was starting to go around and say, Mike Farris might get on the Supreme Court, so let's abolish it. That'd be crazy. That'd be a stupid argument on their part. And it'd be a stupid argument on our part to say, let's not use the thing the founders gave us because of some scenario that's politically impossible to happen. Here's why it's politically impossible. Lots of reasons. Number one, 400 applications for a convention of the states, which, by the way, is the proper historical name. Virginia in 1788 passed the first application under Article 5, and they called it a convention of the states, November 1788. Lots of other things since then have also done that, but that's the proper historical name. It's not some Johnny-come-lately idea. 400 applications, we've never had a convention. Why not? Because you have to have an agreement on the subject matter before you call it. 2/3 of the states have to agree on the subject matter. Well, can you change the subject matter once it's called? I litigated the very case that answers the question. Remember the Equal Rights Amendment when they gave it 7 years to be ratified, and then they added 3.5 years for ratification beyond that? Changed the rules in the middle of the stream. Remember? Some of you are old enough to remember that, the late 70s. I was a young lawyer at the time. I was 7. And so, yeah, amen. Yeah. I was a young lawyer. I was 2 years out of law school. What in the world I was doing this case by myself, 2 years out of law school. But the answer is I was the only one with the guts in Washington State who was willing to do it. And so I represented 4 Washington State legislators, and I filed the first constitutional challenge to changing the rules in the middle of the stream. Now, 2 weeks later, Arizona and Idaho legislators filed a virtually identical suit in Idaho. I dismissed my case in Tacoma, Washington, jumped on a plane, flew to Boise, Idaho, intervened in their case. My intervention motion was granted, and we worked on it together. And we had more experienced people at the lead. Now, I did parts of the case. In fact, I argued the principal motion in the Ninth Circuit when they tried to get rid of the federal district judge because he was a Mormon on its religious grounds. And I argued the religious freedom issue in the Ninth Circuit on the case. Senator Sam Ervin sent me a letter of congratulations for my briefing argument on that issue. And so I was a part of the team. I really was. We won that case. And here's the rule. You can't change the rules in the middle of the stream. So we've litigated. And that's a backup. But there's the biggest backup of all. There's multiple other backups, but I only have time to tell you the biggest of all. So let's just tell you the biggest of all. It's called 38 states. 38 states have to ratify whatever comes out of the Constitutional Amendments Convention, properly called the Convention of the States. And there are 27 states where the Republicans control both houses. That counts Nebraska. It's officially nonpartisan, but it's really a Republican state. And Nebraska doesn't have 2 houses, it just has a unicameral rule, but still. It's 27 states control the whole thing. The governors are irrelevant. Lieutenant governors are not irrelevant, ever. If their last name is Forrest. But governors have no power. Actually, the lieutenant governor could have a vote in the split Senate, so lieutenant governors are not relevant. Or irrelevant, rather. Going too fast. Not irrelevant. Dan will, well, hopefully he won't be that close. But if it is that close, Dan will have a vote. And so but we don't need Republican governors. We don't worry about that. You need 38 states to ratify. There are 17 states where the Democrats control both houses. There are 6 states where the Republicans control one house, the Democrats control the other. How do you get to 38 out of that? Okay, let's just assume that all 17 Democrat states want to repeal the Second Amendment. I don't think you can do that. I don't think you can do that in the 17 Democrat states, but let's just assume, okay? We've got 6 states where the Republicans control one house, the Democrats control the other. They've got to get not just the Democrat house in those states, they've got to get the Republican house in those states. Okay? Let's just assume they can do that somehow. Well, they're at 23. They got to get 15 states. They got to win both houses in 15 states where the Republicans control both houses. Why, when the Democrats have controlled both houses of Congress, have they not proposed repealing the Second Amendment? It's because they know will get killed in the ratification process. And why waste political capital on something that they know is dead on arrival? They can count. It's not because they believe in freedom, it's just they can count. And we ought to be able to count too. You know, we ought not to be the people that are mathematically challenged. And I'm here to tell you, there is no other alternative. The alternatives are as follows. Keep on doing the same old thing we've always been doing, trying to elect more conservative people to Washington, D.C., and hoping it works out for us. Good luck with that. Wishing, and hoping, thinking, and praying. Dionne Warwick comes to mind. Go hide in our bunker and just give up. That's the other alternative. And some people want to do things like nullification and some even secession. Let's talk about nullification for a second. Let's just forget the idea whether nullification is possible. I'll tell you this, it'll be like whack-a-mole. If the state nullifies one of the 50,000 laws that need to be nullified, federal district court will rule the Nullification Act to be unconstitutional. And then you're going to have a showdown. And even if it was successful in the courts, the state would disobey what the court said, Congress will just pass another one in its place, and you're going to, whack-a-mole, boom, boom, and you got 50,000 of these things. It's like trying to get it. Remember that Indiana Jones scene where he got in a knife fight with the big Egyptian? Trying to do nullification is like trying to get in a knife fight with that guy. There's only one way to deal with that. You pull your gun, you shoot him in the gut. And the way you do that is by taking away their power to legislate on domestic issues other than the specific enumerated powers in Article 1, Section 8, like the Patent Office and the military and so on. That's what you do, is you take away their power entirely. You could spend all your time for the rest of your life trying to do that stuff. And while some things, you should resist the federal government where you can, like Common Core. We should, if that's what we mean by nullification, then I'm all for it. Don't take the federal money when there's, Medicaid extension, don't take that. If that's what people mean by nullification, amen, let's do that. Let's stop them right now. But even that I want to take away right now. And let's take the issue of marriage. Marriage, how are we going to get around that? The federal courts are ruling the roost. I want to take away the power of the federal courts to be the legislators of this country. And that's what we can do through our process. We're not aiming at marriage specifically. We're aiming at the power of the federal courts to be legislators, period, on all issues. Beyond that, we're aiming at the power of the federal government to use treaty power to control the domestic policy of the United States. I have personally led the charge to defeat several UN treaties. Bob Dole goes around the country bashing me because I have killed his favorite treaty. He lost me at UN. This is the UN Convention on the Rights of Persons with Disabilities. My mom has MS and has had MS for 40 years. I've pushed her around in a wheelchair, not only in this country, but in Europe, where they don't treat people properly who have disabilities. America needs good policy for people with disabilities. But I think that Americans should make the law on disabilities, not the United Nations. To just beat treaty after treaty after treaty and vote after vote after vote. I want to take away their power to ever use the treaty power to control the domestic policy of the United States. And that's what you can do through the Article 5 process and through the application that we've written. It is safe because 38 states have common sense. And if we don't have any more common sense, and we can't get 13 states, one house, just one house in 13 states to do what's right, America's gone anyway. We might as well give up and go in the foxhole and die now. I believe we have one chance to do this. It's not going to be many years. I'm not a prophet, the son of a prophet. I'm an ordained Baptist pastor, and you're not allowed to do the prophecy. Okay? And besides that, I've been running nonprofit organizations for over 30 years. So I can't be a prophet. We're being running nonprofit organizations, right? You'll get that later. Think about that one. Put it in your pocket, you'll laugh later. All right. But we don't have a long time. I don't know how long it is, but we don't have a long time. And I don't want freedom to be extinguished on my watch. I have 10 children and 17 grandchildren. The irony is, I won a college speech contest advocating zero population growth. Absolutely true story. I got $35. It was the week of the original Earth Day. And for a long time, we celebrated Earth Day by buying $35 worth of disposable diapers. I'm glad to tell you that we're out of that business. I had to say the words last year. I went to my granddaughter's high school basketball game. Those words will age you. And so I have a lot of grandkids. I have a lot of kids. I, like you, don't want to leave my kids and grandkids holding an empty bag. I want to leave them with a country with robust freedom. So I ask for your help. And so before I give you the details of how I want you to help, I want to ask for your questions. So who has questions they want to ask me? Yes, sir, in the back.
Sir, who's going to make H. Suarez from Etowah? Who's going to make the rules of the Convention of States? My reading of the literature tells me that we would petition Congress for a Convention of States. If that's the case, then Congress would be writing the rules. They would be saying who could be part of the delegates of the Convention of States. Correct my thinking, or?
I'll correct your thinking. You're wrong on all counts. But it's a good question, and I get it. In the Seventh Amendment, excuse me, the Sixth Amendment, Seventh Amendment is civil trials, Sixth Amendment is criminal trials. The Sixth Amendment, you have the right to a trial by jury. It doesn't say you have to have a unanimous verdict. It doesn't say how many people are on the jury. It doesn't say you have the presumption of innocence. It doesn't say you have to have proof beyond a reasonable doubt. That's not in the text. But every one of those things is part of the original meaning of jury trial. We know what the original meaning of jury trial is, and we also know what a call of a convention is. It's the same exact thing. So just like in the Sixth Amendment, we have the rules about a jury trial in the Federalist Papers, in the laws at the time, in other original sources. We have the same thing with what it means to call a convention. The same exact thing. And it is, calling a convention by Congress is they get to do two things. They get to name the time, they get to name the place. That's it. A convention of states, by definition, is a creature of international law at the domestic level, meaning these are meetings of sovereign states. This is not a meeting of individuals. And states only meet in one way. One state, one vote. The first step, 34 states have to apply for a convention. One state, one vote. The last stage, 38 states have to ratify. One state, one vote. At the convention, a majority of states have to adopt the actual language of amendment. 26 states, one state, one vote. It's the only way it works. And it's the only way. We've had 32 multi-state conventions in the history of the Republic. Well, yeah, in the Republic. 2/3 before the Constitution, 1/3 after the Constitution. Every single one of them, one state, one vote. The delegates have to be appointed by the states. Congress can't set the rules. Congress can't name the delegates. Congress has never claimed the power to claim the rules in a successful fashion. People who make that argument, oftentimes, and you may have seen people who cite this, cite a Congressional Research Service study. The Congressional Research Service study is not Congress writing. It's some lawyer who's never had a real job, who couldn't land any other job, so they got a job at the Congressional Research Service. And there's a report out that cites a bunch of failed laws in Congress where people proposed laws to give Congress the authority of. Every single one of them failed. You don't make a legal precedent out of failed laws. In fact, the Supreme Court has dealt with this. Even the Supreme Court gets this one right. In Youngstown Sheehan 2 versus Sawyer, when Truman seized the steel mills in the Korean War and tried to justify it, he said it was his executive power and implied and all that. The Supreme Court said, well, actually, Congress looked at passing a law just like the one giving you just like the power you wanted, and they voted no. That meant Congress didn't want you to have the power. If there's any precedent created by a failed law, it's the opposite of what they're saying. So the Congressional Research Service person doesn't know what they're talking about, and the lawyers who are kind of out there on the edges of things who say the contrary. Now, at some point in time, this leads me to the comment on this. Who do you believe on this subject? Let me tell you who's on my side on this issue. Let me give you some political people, and then I'll give you some legal people. On my side, Alan West, Sarah Palin, Tom Coburn, Mike Huckabee, David Barton, Glenn Beck, Sean Hannity, Rush Limbaugh. They're all on my side. David Barton's lawyer, Rick Green, and lots more people. Legal people that are on my side. Chuck Cooper. Chuck Cooper is the outside counsel for the NRA. He was the head of the Office of Legal Policy under Ronald Reagan. It's the #3 position in the Justice Department. He was a top legal scholar for the Justice Department, former Supreme Court law clerk. John Eastman, another former Supreme Court law clerk, he's been a law school dean, he's a law school professor now. He is the head of the chairman of the National Marriage Project. He was also part of the Reagan judicial team. He's on our legal board of advisors. Mark Levin is on our legal board of advisors. And obviously is the author of the Liberty Amendments, which is exactly parallel to our, Mark Levin has specifically endorsed our project. Who else is? Rob Nadelson, who's the top Article 5 scholar of all time. He's published more Article 5 articles in law reviews than everybody else in the world combined. Ed Whalen, another high-level Reagan Justice Department guy, is on our legal board of advisors. C. Boyden Gray, former Republican White House counsel, is on our side. And so contrast that. People who've argued repeatedly in the Supreme Court have arrows in their back for 30, 40 years of legal practice in conservative politics. You got some woman down in Florida who was a misdemeanor prosecutor for 5 years and lost her job in a political battle, and now she's off teaching the Constitution. She cites the Congressional Research Service. She's alone in that position. Folks, who are you going to believe? You know, this lady who means well? I take people like her and other people who mean well and say this. It's like a football player who intercepts a pass and runs the wrong way down the field. They mean well. They think they're doing a good thing. They've got the ball and they think they're going right, but they're going to score for the other team. And so people, you know, I debated with John Birch Society about this in Oklahoma. The guy that I was debating, I was arguing for nullification. I said, Charlie, when you find out that nullification isn't big enough and powerful enough to do what you want, I mean, I agree with the sentiment, but it's not big enough and powerful enough. When you figure that out, why don't you come help me in Article 5 then? He said, no. When we figure that out, if we figure that out, then it's time for secession. I said, Charlie, you mean to tell me that you would deliberately rather destroy the Union than take a chance that something bad might go wrong at a convention of the states? He said, yes, I would. I debated Andy Schlafly in New Jersey. Andy is Phyllis Schlafly's son. Phyllis is a wonderful woman. Has made one political mistake in 50 years of politics. Everybody's entitled to make one mistake, and she's wrong on this issue, in my opinion. Andy, her son, I asked him, Andy, when is it going to be time to use Article 5? You admit it's in the Constitution, it's there for a purpose. When's the time? He said, when they impose martial law. I said, Andy, there's only one response when you impose martial law. It's get your guns, boys, let's take our country back. And so if we're willing to wait until, that's, you know, calling for secession is dangerous talk. Calling for martial law, you know, or saying we'll wait till martial law is dangerous talk. Ladies and gentlemen, I don't want to wait for those things. I don't want to blow this country up. I want to save the country. And I think that we ought to avoid people who are advocating dangerous talk. They mean well. They really do mean well. But they're just wrong on this issue. And they're pursuing dangerous ideas. Yes.
Dr. Farris, in our dream world where we could actually maybe accomplish this, paint the picture of what actually, say we actually are successful and do the things that we would like to do, how does that actually affect existing laws and all these executive orders and, you know, what goes on after?
Okay. Well, I'm going to answer your question first, and then I'm going to tell you why it's not a dream world after you get done answering. Okay. So it's going to depend on what the issue is. If, for example, we say there are term limits on the Supreme Court, you'll say this amendment shall take effect X, 18 months after ratification. Okay? When that happens, all all the existing members of the Supreme Court will be term limited out, and you'd replace them in the process, named in the process. I prefer the states naming the Supreme Court, and that's, if that's successful, you get a new round of Supreme Court judges named by the states. There'd be some, in terms of shutting down various federal agencies. I used to work across the street from the Department of Labor in their cafeteria. One of my lifetime goals was to turn that building into condos. And so, because that's a state issue, not that there shouldn't be labor rules, but it should be state labor rules. And so, a program like the Department of Labor, that could be shut down in about a 2-3 year kind of a time frame. You're going to have transitional periods. And you'll have to have transitional periods that vary depending on the complexity of the issue. Some of the entitlement programs will have to have longer transitional periods. But nonetheless, there will have to be transition periods. Here's why it's not a dream. Here's why this is going to happen. There are 4,000 state legislative districts in 40 states that we're targeting. We're not targeting California. We're not targeting Massachusetts. We're not targeting Hawaii. Even though I'd like to target Hawaii and go out and testify, we're not targeting Hawaii. Because, like the Democrats and liberals, we can count. Okay? By the way, this should not be a partisan issue. Democrats should be as much in favor of local control as Republicans should be in favor of local control. If California wants to run California in a socialist fashion, it's more power to them. Let them see how it works out for them. And, because all we're arguing for is who makes the decisions. We're not saying what the substantive decisions have to be. We're just trying to transfer substantive decision-making back to the state level. But nonetheless, being a political realist, I'm not counting the heavily Democrat states. All right. So in the 40 states, there are 4,000 House districts. Our goal is to have 3,000 of districts, 75%, politically organized. Politically organized means I have a district captain and at least 100 people in that state that are willing to stand up, speak up, and show up. Meaning they're going to contact their state legislator and state senator and say, vote for a convention of the states. I have presented this plan to hundreds of state legislators. I only need 1,500 House members nationwide to vote for this for it to pass. 1,500. I have presented to approximately a third of that number. And there have been none of them have ever said to me, in fact, they've said the opposite. If you actually turn out that number of grassroots people, then this will pass. So what's the possibility of doing that? Well, you take 3,000 districts times 100, that's 300,000 people. Homeschool Legal Defense Association has on its emailing list 300,000 families. I built that list over 32 years. My partner in this, Mark Meckler, was the co-founder of Tea Party Patriots. Tea Party Patriots has 4 or 5 million. Now, he doesn't have access to that list, but he built it once, and we're rebuilding a lot of that again. We can get to 300,000 people. That's 1/10 of 1% of the American population. And let's just multiply by 10. Say we really need 1,000 for this. That's 3 million people. Are there 3 million people who believe in this in the country? The answer is yes, there are. 1% of the population believes in the principles of liberty, believes that local government's better than national government. And why will 1% win? Because this is lobbying, not elections. And 1% of the population never participates in electoral activity. We will win. We will have more people than they will have. If we can turn out 1,000 per legislative district, we can win. This is no pipe dream. This is based on 30 years plus of legislative experience where I faced down the teachers union, the State Board of Education, and all the other education establishments. And they are all supposedly so powerful in the states. We faced them down with parents relying on the power of God, doing what's right, and out-hustling them. And we won homeschool freedom in state after state after state. And we can do it again. Yes, sir.
Okay. Earlier you said that if the state regulates something and pays for it, then the federal government can't do the same.
Should know the original meaning of the general welfare laws.
Okay, now does that mean that the government should not grant funds to schools or give money to schools like that?
Right. It means, here's the fiction that's in place right now. The federal government steals the money from the taxpayers.
Yeah.
Taxpayers of today, taxpayers of tomorrow. They ship it to Washington, D.C. They skim off a whole bunch of it to run the Federal Department of Education. They send a little bit back to the states and say, now, do the will of the voters from other states rather than the voters of North Carolina. That's not federal funding. That's taxpayer theft funding. It'd be just smarter to leave the money in North Carolina in the first place and not ship it off. We shouldn't just cut off the federal, sending it back. We got to cut off the whole system. Don't let them take the money from North Carolina in the first place. That's how the system has to work. You do that, then the system makes sense. Doing half of it doesn't make sense. You can ask a follow-up.
Okay, and then what about categorical grants? Are those constitutional?
If the categorical grant for military operation, it has to be related to an enumerated power of Congress.
Okay.
If it's not according to a enumerated power of Congress, then they can't do it. Yes, ma'am.
You're going to need some sort of mediator for this convention of states. Are you willing to take that position, or are you looking for somebody else taking that position?
Well, there'll have to be a chairman. By the way, who adopts the rules? The convention adopts the rules. How are the convention going to adopt the rules? There are state legislators right now, including 2 legislators from North Carolina, that are helping to write proposed rules. The victory goes to those who are prepared. And they're not official until the convention happens. And they're also, the plan is to get 26 states to instruct their delegates to adopt the Mount Vernon Assembly rules. That's what they originally, they may change the name, but that's what the group was called originally. So it's bipartisan legislators from all over the country that are writing even-handed rules on committee practice and procedures and all that. They've already adopted the overarching principle, can't change the subject matter, one state, one vote. And so that's going to be the recommendation. Yeah, I'd love to be the chairman of the convention. And I plan on being a delegate from Virginia, but the General Assembly of Virginia has to appoint me. I can't self-nominate. Yes, ma'am.
You say that, in first place, I agree with the necessity of doing something on the qualifications. You say that on your side, there's a lot of good folks. Well, there are also people like the Move to Amend Coalition, including Alliance for Democracy, Center for Media and Democracy Code King, Independent Progressive Political Network, Progressive Democrats of America, Sierra Club, Vermont for Single Payer, George Soros, and Wolfpack are also in favor of the COS.
Sure, and they're in favor, all these liberal groups are in favor of COS. And they're also in favor of electing people like them to the U.S. Senate. And they're also in favor of electing people like them to the President of the United States. They're also in favor of, yeah, my turn. I came a long way here to do this, so I want to answer your question. You asked the question, I got it. I'm not misunderstanding you. There's a lot more. There's a lot more. Most of those are just websites. They're not real organizations. We've checked those people out. There's only about a dozen of those that are real organizations. Most of them don't really exist. Somebody signed their name on a piece of paper. But there's a dozen big, powerful groups in that, like the Sierra Club and George Soros. So we got the idea. There's a lot of lefties that like this idea too. But it's just a political process. It's just like running for the Senate, like running for president, like running for the state legislature. Yeah, go ahead.
So that if these people are gung-ho for the subject, they're going to be alert, they're going to want to be made delegates.
Sure.
What's to prevent the same thing that happened at the original?
Oh, goody. I'm glad you asked me this one.
Okay.
Oh, good. All right. Okay. Is this a tornado warning for you? Flash flood?
Flash flood.
Okay. All right. Okay. All right. Let me. Okay. All right. Oh, goody, 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 goody. Thank you so much for asking that question. I was hoping somebody would ask me. Let me answer. Okay. First, those groups are trying to get Article 5 convention for their issue. They want to reverse Citizens United. They got 3 states. They don't mix and match. You have to have an agreement on the subject matter. If they can get 34 states to call a convention for their purpose, Lord bless them, they've got the right to do it. They got the right to try. They're not going to get anywhere. Do the math. They can't get to 34 states. The second thing is that they can't hijack ours. And the reason they can't hijack ours is the reason that is that the history that you've been taught about the Constitution is not true. So I'm going to teach you the correct constitutional history right now. Because what we are doing by repeating the old statement, by the way, I used to believe the same lie that you believe right now, that the Constitution was illegally adopted as a result of a runaway convention. But if you just think about it for half a second, calling yourself a constitutionalist while believing the Constitution was illegally adopted is pretty schizophrenic. And so let me tell you why it wasn't illegally adopted. And so here's the history you didn't learn. We're going to start with the Annapolis Convention. At the Annapolis Convention, Virginia called it, wanting to talk about commerce. Now, the Annapolis Convention, now this is a technical legal term. It took me many years of study to be able to understand terms like this. I hope I can explain it adequately. It's called a Yada Convention. What a Yada Convention is this? You ought to do this, you ought to do that, you ought to do the other. It didn't have any actual power. It was coming together to make a recommendation. Okay, so they held a Yada Convention, and 5 states showed up. It was in Annapolis, Maryland. Maryland wasn't one of the ones that showed up. It wasn't convenient for Maryland. And so they quickly concluded 2 things. Number 1, they didn't have enough states. Number 2, they didn't have any actual authority. So they said, we want to go back to our states and ask our states to call an actual constitutional convention and to give us broader authority. And the authority they wanted, they were recommending to the states was to, and I quote, render the federal constitution adequate for the exigencies of the Union. That was the quote. Now, that was a Yada resolution. That was no more powerful than a National Pickle Week resolution today. All right? So, we go to the states. Virginia and New Jersey, on the same day, call a real convention with real authority. And they appoint their delegates. They name them by name. They give them their authority. And they give them their assignment. And their assignment was, and I quote, render the federal constitution adequate for the exigencies of the Union. Not a word about only amend the Articles of Confederation. Where did that language come from? It came from a February 1787 resolution by Congress. A resolution by Congress, now you know what the legal term means. It was a Yada resolution by Congress. Congress didn't have any authority to say anything about this other than a mere endorsement. Why do I say that? Under the Articles of Confederation, what we know from history, if you know anything about the Articles of Confederation period, Congress had 0 implied powers. There was nothing about calling a convention in the Articles of Confederation. They couldn't call a convention. They couldn't name delegates. They didn't call the convention. They didn't name delegates. What they said, and I'm quoting, Congress is of the opinion that it would be expedient to hold a convention in May in Philadelphia. The same date and time the states had already named. 7 states had already called the convention, named their delegates, named the time, named the place, gave them their authority. Delaware, by the way, told their delegates only vote for a procedure that leaves the states in equality. And that's why we got the U.S. Senate, is because Delaware delegates obeyed their instructions, the instructions they were given by their state legislature. And so two states after Congress voted, Massachusetts and New York, here's the surprise, said 2 things. They said, render the federal constitution adequate for the exigencies of the Union, and only amend the articles. So we've got 2 states in question. The New York delegates thought they were violating their instructions, and they went home. Massachusetts State, James Madison in Federalist 40 defends the actions of the Massachusetts delegates. But it's a historical footnote about whether the Massachusetts delegates obeyed their instructions. It wasn't the whole convention. 10 of the 11 states that were actually functioning at the convention had the exact same instructions. Render the federal constitution adequate for the exigencies of the Union. Now you're going to say, oh yes, but they changed the ratification rules. No, they didn't. They did it right. And here's how they did it correctly. The state delegations that were called into being in the first place said that they were to send it to Congress and then have all 13 state legislatures ratify. It was parallel with what the Articles of Confederation did, but it wasn't under the Articles of Confederation because they were using the residual sovereignty of the states, not the process of the Articles of Confederation, because there's no convention in that process. So Congress voted 2 things to approve, unanimously. They approved the new Constitution, they approved the new methodology. They didn't send it to the 13 ratification conventions. That would have been improper. They sent it to the 13 state legislatures, just like the call told them to. What did the 13 state legislatures do? Including North Carolina, it's very important. The 13 state legislatures could say yes or no to the new process. They were asked to say yes to the new process. How did they say yes to the new process? They voted to call a convention. How many states legislatures voted to call a convention? All 13 state legislatures voted to call a convention, including Rhode Island that voted to reject the Constitution, including North Carolina voted to table the Constitution. But that was the conventions, not the legislatures. And so the question is, how many legislatures approved the new process? The answer is 13 approved the new process. It was unanimous, just like it was supposed to be. And once they approved the new process, then of course it's perfectly lawful to use the new process. There was no runaway about it. And I know you mean well, I know that other people here mean well, but we've got to stop defaming the Constitution of the United States. Stop undermining the Constitution of the United States. It was properly adopted, it was properly ratified. The states called the convention, not the federal government. The states gave their authority to the delegates. The states told them, render the federal Constitution adequate for the exigencies of the Union. And that's exactly what they did. They followed it throughout the process. And why would we listen to people like Warren Burger? Warren Burger has poo-pooed the legitimacy of the Constitutional Convention. Warren Burger, who wrote to Phyllis Schlafly, again, inexplicably to me, why Phyllis would listen to the co-author of Roe versus Wade. And so, you know, who you're going to trust on whether they follow the process correctly, Warren Burger or James Madison. James Madison in Federalist 40 lays this all out. Go read it afterwards and you can see that he gets it right. And I've got a piece of paper over here, 2 pages, that reteach you this history. We shouldn't get our American history from the Common Core. We should get it from the actual... Okay. The answer is, we are going to change the Supreme Court. If we just do this piecemeal, there's some argument for that. However, Congress, here's probably what would happen. They'll ban it for a while, and then they'll find ways around it. That's what they would do. And so, let's say if I had to predict, if we don't fix the Supreme Court, then it'll ban it for a while. Maybe 30, 40 years. And yeah, me too. I'll take 30, 40 years of liberty. And what we've done is we've legitimized this process. We'll never be afraid to use it again. And Washington, D.C. will walk in fear of the states for the rest of forever. And that's what we want to make. If we're successful in fixing the Supreme Court, all this gets much better. Yes, ma'am.
I got this book
Yeah.
at a pastor's meeting.
Yeah.
Rick Scarlett, and he's handing this out to everyone. And these are fantastic books.
Yeah.
And I was reading something from a constitutional convention of Ben Franklin, and you probably read a lot of this. And he said that in this statement he made, he talked about that except the Lord build a house, they labor in vain. That build it.
Right.
And he also says that he believes that, I also believe that his concurring aid, we shall succeed in the political building no better than the builders of Babel. So if we do all of this stuff as everybody's saying we need to do, and we keep God out of this, we are laboring in vain. So I noticed tonight, we never said the pledge, we never had prayer, and I'm thinking, where does all of this, God, our forefathers, came into this country because he brought us forth this way.
Deists were also part of this country. They were non-interventionists religiously, so why not keep religion out of it right now and continue what we're trying to do? Because I'm here to support it, and I would love to.
Because it's right.
There's many of us here who that's irrelevant. We're still here supporting the cause.
But I'm talking to him.
Okay.
Thank you.
All right. All right. The cause is a cause for all Americans. What motivates me, I don't do anything in my life without depending on God. You heard me say, if you're paying attention when I talked about the homeschooling movement, because we depended on God, we were successful. There's our staff meetings, we pray. But we want to present this in a way that this is for all Americans, because frankly, I want to preserve the free exercise of religion in this country. And we have a real problem with the free exercise. Why? You know, Christians do in specific. The whole idea that a baker in Oregon is being civilly fined for refusing to make a wedding cake for same-sex marriage, photographer in New Mexico, florist in Washington State, you know, et cetera, et cetera, et cetera. And here's the way I look at it, and I will talk from a religious perspective for a second, just an analysis. Washington, D.C. thinks it's God. And it's a false God, in my opinion. But here's why I say that. Ask somebody what they think will solve all your problems. And if you ask that in Washington, D.C., what will solve all of man's problems is centralized government. And so we're trying to take down the God of centralized government and return to the states limited government, because that's the atmosphere. Why do I do that? Because that's the atmosphere where religious freedom blossoms. Where religious freedom blossoms, from my perspective, Christianity blossoms. And I want the freedom to preach the gospel of Jesus Christ. But here's a, you know, just, I'll give you a snippet into my life, which I think illustrates the point. I would have been fine. It's my oversight that we didn't say the pledge at the beginning and so on. I'll take that as my responsibility. But nonetheless, I was in federal court in East Tennessee in the 80s. And the issue in that case was whether or not Christian kids could be forced to read textbooks that the public school district stipulated violated those kids' religious beliefs. The family asked for alternative readers. They just wanted to, you know, actually they just wanted to use the books that the school district had used the year before. And I was facing down People for the American Way. And the lawyer in People for the American Way argued that, well, Mr. Farris, all he's formally doing is asking for an alternative reader for these kids. But what he secretly wants is to ban these books. And Judge Hull looked down and said, "Oh, Mr. Dye, I'm pretty sure that Mr. Farris wants everybody in this courtroom to get saved, but he's not asking me to order it." And he was right on both counts. I did want everybody to get saved, but I wasn't trying to use the power of government to order, because I believe in soul liberty. And I believe that by standing up for God and for freedom, you know, I've got a 35-year record of doing this. And, you know, I'm lots of ways. I depend on God daily, and you can't find anything. So I would, you know, just say, look at the totality of my record and don't judge, you know, isolated facts too strongly. I am depending on God. Our team is depending on God. But we do want to welcome everybody, because freedom is for everybody. Yes, sir.
17th Amendment, forgive me if you discussed it earlier and I missed it, I was late, my fault. Did you bring that up?
I have not talked about it. Mark Levin's book, The Liberty Amendments, proposes repeal the 17th Amendment as one of the things that needs to be done. Our application is germane. So that's the way we've written the application. That's a germane thing. Now, Mark, I want to do more, and I'm fine with doing that, but the main thing I want to do is to take away their domestic authority. And so I don't want the 17th Amendment. I mean, the main reason you'd want the states represented directly in the Senate is so they have a say on the domestic issues. I want the domestic issues decided at the state level, period. And so.
And would you consider also supporting, say, federal candidates for U.S. House who specifically say they will be keeping a very strong, I know they can do nothing, but they can at least verbally say that much of their authority that many look to should be sent to the state level? Would that be?
Well, I'm personally in favor of that, but our organization is we're not focused on federal elections, because we don't want to give the idea that the federal government is any more powerful than it used to be. We want to keep our focus on states. And if a congressman or a senator wants to endorse us, fine. We're not running after them, because we don't want to give the idea that we have to go bow in Washington, D.C. We want to promote an attitude. This is about the states. This is time to reestablish the states. You know what? Not because the states are so wonderful, but because the people have better access to their government and state. This is the way you protect the rights of the people, is to bring the decisions back to the state government. Who would like to ask? If we've run out of questions, that's weird.
Question about qualification for work at the tax law. The state government would stand up and say, we're not going to accept, say, on EPA or alcohol, tobacco, firearms. You say, no, we're not going to enforce this law.
Okay, just, the main reason I don't think nullification is realistic is because there's just too much to do. Too many things to know. And you're going to be fighting in a forum where the cards are all stacked against you. They got the federal courts on their side, they got the U.S. Army on their side, they got all kinds of things on their side. And when I want to fight, I want to fight in a forum that I've got the advantage. I was a lifeguard for 5 summers as I was going to college the first year of law school. 4 years on a beach, 1 year in a pool. After being a beach guard, being a police officer. But the first beach I guarded at was on the Columbia River in Washington State. And it was a nice family beach every week except one. We had unlimited hydroplane races in our park 1 week a year. And it was a wild place that week. And the carnival workers and just motorcycle gangs, and the other people that came to the beach. It was a rough and tumble beach for 1 week. And if I had to get into a physical scrape with somebody, I didn't want to fight them on the beach. I would entice them out into the water. We'd take it over. We'd take it on there, and they'd take a little tour of the bottom of the lagoon for me. Because in the water, let me finish.
You're going off on a story, right?
The point of the story is, I fought them where I had the relative power. And if we're going to fight the federal government where we have relative power, we do it in the state legislatures through the Article 5 process. If we're fighting them in federal court day in and day out in nullification litigation, which is where it would go, and let's assume we get a governor who's willing to call up the National Guard to stop the U.S. Army. What we're doing is we're saying we want to go to war. Why would we want to go? Well, maybe you do, I don't. I want to use a peaceful constitutional method. I'm going to kill my Christianity at this point. As a Christian, I don't believe that I can advocate a violent method of dealing with a problem when I have a nonviolent, lawful method under the Constitution of the United States available to me, and I'm just chicken to do it. And so well, I've argued 2 amendments of the Constitution and the courts more than any other 2 in my life. First Amendment, the Fourth Amendment. The Fourth Amendment is unreasonable searches and seizures. So if you've got evidence that drones are flying over your house, they've invaded your space, you call me up. I'd love to take Fourth Amendment case with you.
Wait, I have one more question.
Sure.
Okay. If we have to use the counter passport to track one down, we in trouble. Probably, right?
Well, I don't know. I don't know that there is a giant.
They have to get hawking.
Yeah, I don't know about that. That's beyond my knowledge base. All right. Yes, sir.
Now, at the state level, you have the problem at the state level, people not actually listening to
Well, see, nullification as a concept is that the state government should intervene and stop the federal government from taking action. Here's what we need to realize. The ultimate check on all forms of government abuse is in this room. It's the people. And there was a guy his name is George Nicholas, at the Virginia Ratification Convention, who said, he was responding to Patrick Henry's argument that the government was going to run away with itself under the Constitution. And Nicholas said, an enlightened people will never suffer that which is imposed for their liberty, which is created for them, to protect their liberty, to become an instrument of tyranny. In other words, the Constitution won't become an instrument of tyranny because enlightened people won't let it happen. Okay, so it's happened, so what's the conclusion? The people haven't been enlightened. And what do enlightened people have to do? You have to know what's going on, you have to know how to respond, and you gotta get up on your own two hind legs and do it. That's what enlightened people have to do. And if we follow that, we can stop them. And if we transfer things from the federal level back to the state level, it's not gonna be utopia. There's never gonna be a utopia until Jesus comes. And so, it's gonna be, we have a better chance of fighting for our liberty, having government that works, where the economy can flourish, our freedoms can flourish. People can live their lives in peace and quietness and not be worried about all this stuff. And so, because you have better access to decision makers at the state level than you do at the federal level, it's just a simple matter of the people having face-to-face access. And they represent fewer people. The more people a legislator represents, the less conservative, less responsive he is. You want to know why California is the most liberal state in the country? It has, per capita, it has the largest legislative districts in the country. The California state Senate seat has more people than a U.S. congressional seat. They have enormous power. You get the power spread out, you get the people actually contact the people, you have better government all the way around. Yes, ma'am.
One last question.
Okay, one last question.
Well, I was just going to say that the left is very good at gathering forces. Quick, they're fixing it. At least the Shemak, though, they mobilize. They start mobilizing. They get a hint of this stuff. It looks like it's going to succeed or get legs of it. They're going to mobilize like nobody.
Good, let them mobilize. You know, this is just, I'm not afraid of George Soros, I'm not afraid of any of these people. When I was a young lawyer, I took on the porn industry. I got death threats, I had my window shot out. That's when I first got my concealed carry permit. The police chief told me it's better to be tried by 12 and carried by 6. That was his advice on what to do until I got my permit. But I'm not concerned about anything. I have faced these people down for 34 years. And, you know, the liberals in the porn industry, the left, who run for office. I am not afraid of these people because they have power in New York City, in Washington, D.C., in L.A., and San Francisco. Fine. California gets one vote in this process. Massachusetts gets one vote. I've got Idaho, Arizona, Utah, Colorado, Arkansas, all the South, whole South, most of the Midwest. They've got 17 states. We've got 27. I can count. Why should I be afraid of them? And so let them organize. And let them have the most radical people they want for their 17 states that they can control. Yay and amen. It'll be like, let them go for it. I'm not afraid of these people because I believe in the people of the United States. And I believe in the power of Almighty God. I'm not just saying that to what I would have said anyway. I believe in the Constitution of the United States. And so I walk with the confidence that the people of this country can take this country back, not by anything radical, not by anything dangerous, but by simply following the 1, 2, 3 steps of the Constitution. 34 states pass an application, 26 states make the amendments at the convention of a particular text, 38 states ratify. You can't get anything really radical on either side through that. You can get legitimate, common sense, conservative ideas through that process. And the people want things like term limits, balanced budget, limits on the federal courts, no international law controlling our lives. Those are the kinds of things that have wide appeal in this country. Lots of people do it. And if you would like to help us out, I would ask you to, there's a petition over here. It's just a piece of paper. I want your name and address so I know what legislative district you're in, and your email address, because that's how we communicate with you. And when it comes up for a vote in North Carolina, I can send you an email saying, it's coming up for a vote, I need your help. And so what I need you to do is just call your legislator. That's the basic. If you want to do more than that, Mike Clarkenberry, Mike is in the back here, waving his hand. If you want to help on an organizing kind of basis, go see Mike and we're down. And you can become a district captain or some other way of organizing. Thank you for coming. Dan, I'll turn it back to you.
we're enlightened a little bit tonight. I know I was. I learned a lot from this discussion, and we're going to continue these across North Carolina as well. The next one is going to be on the 28th of this month in Greensboro. So if you have some folks in that part of the state that you would like to send to Greensboro to learn what you learned tonight, then please do that. Also, if you would follow up with Dr. Farris through this information he has on the table. But thank you for coming. You were troopers. That was about an hour and a half of a solid discussion on this, and thank you for that. And thank you for the civility tonight as well. We appreciate that. And be safe heading home. The weather's pretty bad out there, so take your time getting back. I know some of you came a long way to get here, so comment in the back, yes.
Just one question for people that would like to have been here and couldn't. Will there be any way to access anything on the internet? As far as any of these presentations go?
I had this recorded last week, very similar, and it's up. It'll be up on our website really soon. And so you can go to conventionofstates.com website, and there. I mean, this was being recorded tonight, but there's been other versions of this that are not less than 2 weeks old that are up and available on the internet. It's very similar.
Great, thank you.
Yeah, thank you. Great question. Yes.
Dan, there's just been a flood warning just for Henderson County issued, so yeah, please folks, be careful.
Say please, as you have, take your time. But thank you for coming. We appreciate your patience on this. We appreciate you just learning more about this process, and we hope you'll continue to do that. And don't hesitate to contact our office or Michael Farris about this as we move forward. But thank you very much for being here.